all of the attendees, not for you guys as much, more for our other attendees, just to not be taking pictures of their screens or anything on their end.
We don't need to smile, in other words.
Also, to just let everybody know, this event will be held under Chatham House rules, so our attendees are allowed to take any information that they'd like from this event, but they are to keep the identity of the person they got the information from anonymous. I will be sending the link in the chat if anyone else is interested in learning more, but it's also here on that slide if you're interested. So without further ado, our first speaker that we have today is Anthony Bryant. Whenever you're ready, you can take it away.
Thank you very much. It's tough speaking to a screen that's only got my picture in it so far. I can't see any of you, can't ask for a show of hands. I have no idea how many people have signed on. So it's a bit unusual for a trial lawyer to speak to people without knowing what the audience is. The practice of criminal law is theater in action. It was once described by a famous actor as being actors with brains type of thing. I'm old enough to be your grandfather. And I know that because I have a granddaughter who is going to be graduating from university next year. So I sort of have some sense as to the age group that I'm speaking to. I started out thinking that I was going to be a corporate lawyer. That lasted about 30 seconds when the Bank of Dad shut down after law school. I went into civil litigation initially with the Federal Department of Justice. I could only take that for 5 or 6 months because I got no help from anybody there to know how to do it, to learn how to do anything. So I joined a civil firm for a year and learned less. So my foray into criminal law didn't begin until I was about a year and a half out. But I've been at it now for some 48 and a half years. And it is one that one learns by simply going to court and defending a client who you've interviewed, whose brief you know something about, and you put the crown to the strict proof of its case. It took me quite a while to find my feet. The first case I had was in front of an infamous judge in Toronto who's better known for his misogyny than anything else. But I ended up calling my client in his own defense, and the judgment included the comments that, but for my calling my client in his own defense, he might well have been acquitted. But the judge encouraged me to carry on, and here we are. I was very fortunate about 8 years in to come into contact with a woman who I believed and still believe was one of the brightest and best criminal defense lawyers that we've ever had in Canada, a woman by the name of Marlis Edward. And I remember doing a trial with her. I had been practicing, I guess, with 8 years. We were doing a homicide case up in Sault Ste. Marie. And I arrived with a file that you could probably get into a small briefcase. And she arrived at the airport with 6 banker's boxes of materials to defend her client. It was an epiphany for me, and it changed the way I approached defending cases from that point on. There's no question that from the perspective of a criminal defense lawyer, there are a number of different ways to defend an individual. But the one thing that you have to be able to do at the end of the day is to be able to look yourself in the mirror and say, did I prepare well enough? Did I do what I needed to do? Did I put the right questions to the right witnesses? And did I try? If you can't say that to yourself, then probably not in the right forum for you to be in the field that I am. I soon learned, particularly after coming into contact with Miss Edward, that one needed to be better prepared than the Crown, the witness, and the judge. Unfortunately, in my career, I found that failing to pass first year physics, first year biology, first year chemistry put me behind the 8 ball when dealing with experts from Center of Forensic Sciences and other places. And so one had to, and I did, get into learning the science behind many of the things that we see in court on a daily basis. I don't do impaired cases, so I didn't have to learn the intricacies of the breathalyzer machine, but I certainly learned a lot about DNA. I certainly learned a lot about cell phones. And I learned a lot about blood stain, spattering, that kind of thing. And it turns out that if you know that you're comfortable with the material, you can do a very, very good job. One of the things that we are faced frequently is whether or not we can feel comfortable in defending a person whom many believe is guilty. And that's not something that I have ever concerned myself about, because I wasn't at the scene of the crime. If I was, I couldn't be the defense counsel. Unfortunately, there are cases where people take videos of what happened, and you can see what your client did or did not do. So in those cases, for instance, it would be improper to present a defense of an alibi. Clearly, if your client's showing his identification to the surveillance camera and saying that he's about to go in and attack someone in the convenience store, for him to get into the witness stand and suggest that he was somewhere else in the country at the time, he could not do. So I found that in my practice, you have to be in control of the case. And it's preparation, preparation, preparation. It's a long hours, unusual hours, often between 2 and 5 a.m. When you wake up in the middle of the night thinking, I should ask this question or that question. I think that being comfortable in your own shoes is very important, and that particularly is the case when one is doing jury addresses. I've had the privilege of going before many, many juries. I use PowerPoints. I use cartoons. I use historical events. The story from Alice in Wonderland when the knave stole the tarts. I have used all sorts of materials during the course of my career to try and get a message across. And one of the challenges that I face at this stage of my career is to understand whether some of those stories that I grew up with, some of the history that I grew up with, still resonates. And I have taken it upon myself to almost always within budgetary limits, have the benefit of someone who is still in the first 10 years or so of their criminal law practice, so that I know what LOL means in a text message, or I know what a particular hand gesture might be in gang culture. These are things that one needs to do to stay current and to be effective in court. I have had many jury addresses reviewed by some of my younger colleagues, and they didn't have a clue as to what I was talking about, so it created major rewrites. But for those starting out, it is without a doubt the best thing that I have ever done. It is a thrill for me to go to court. I've told many people that as soon as they hear anything from me that it is not, I'm not getting butterflies going to court, then just, take out the proverbial gun and shoot me. Because then I'll know that I'm not in the game anymore. I would encourage people to go into this who are interested in criminal justice. And I would just close at this stage of these proceedings with saying justice is not to get a conviction, which is what 99.999% of the public thinks it is. Justice is ensuring that the Crown calls its best case, you challenge the case to its fullest, you present the defense to the fullest, you poke holes where you can, you raise whatever reasonable doubt you can, and you let the chips fall where they may. And I'll leave it at that for the moment.
All right, thank you so much. That was very informative. Really appreciate you sharing all of that experience with us. We're now going to move on to Mr. Gary Wiseman whenever you're ready.
Okay, thank you, Bianca. So just by way of background, I was born in Montreal, and I went to McGill and received my civil and common law degrees in 74, 75, and practiced in Quebec up to 1980, and then moved to Toronto, where I passed the Ontario bar, and I do employment law, a lot different than criminal law. So the basic rule in employment law is governed by the Employment Standards Act for non-union people, and that sets out a minimum, so that just like minimum wage, which was increased on October 1st to $15.50, you cannot give less notice of termination than under the Employment Standards Act, but you can give more, and that would be called the common law. So for example, the Employment Standards Act sets out the rule of thumb that for each year of service, the employee is entitled to 1 week of notice or pay in lieu of notice, up to a maximum of 8 weeks. To get severance, you have to follow the regulation where an employer has more than 50 employees and a payroll of 2.5 million, and then that employee can get another 1 week a year up to 26 weeks. So for example, if a small company just has 10 people and a guy works for 6 years and the contract is very solid, they'll only get, 8 weeks, 1 week for each year. But if it's with a big company and they work 15 years, they'll get 8 for the notice and then another 15 pro rata for their 15 years. That sets out the minimum, and that our job at the employment bar is to see if we can get them more under the common law, which is the judge-made law. So there have been some recent developments. In November of 2020, I would say that, because of a Court of Appeal decision and leave to appeal was refused at the Supreme Court, I would say about 95% of the contracts that were drafted before November of 2020 are now illegal, and we're consistently getting common law notice instead of the minimum under the Employment Standards Act. And that's because the Court of Appeal said that when you have a contract that says you could be fired for cause and get nothing, that contract will now be valid under the law only if you had put in the wording willful misconduct because of a regulation under the Employment Standards Act. So before 2020, no contract really put in willful misconduct. They just said, you know, we could fire you for cause and give you nothing. So all those contracts are now null and void, and we're seeing a major amount of litigation where cases are now decided on the common law instead of the Employment Standards Act. Now, willful misconduct, of course, is something very, serious. Obviously, if you rob a bank and you've been there for 25 years, you're going to get nothing because there's been a breakdown of the employment relationship. But if you make an error in judgment, and they say, well, we have cause to fire you, and they didn't put in their hire contract willful misconduct, you're going to get common law notice. So that's a major advantage to the employee now, because there's been a, let's say, unequal bargaining power between an employee and an employer. When you start off, they try and make their contracts airtight, and it's very unfair, that someone should work 24 years or something and only get 8 weeks when the maximum that the court will allow would be 24 months, which is a month a year. And it all depends on how the contract is written. So it doesn't matter if you work 40 years, the Court of Appeal has said that 24 months would be the maximum that you should have in terms of payment or notice, because that's the maximum it should take you to find another job. It doesn't matter if you're out of work for 3 years, the most you could get is 2 years, but you have an obligation to mitigate your damages and seek alternative employment if you're let go at the same level and the same salary. So you can't just sit at home and then hope to win money. You have to show that you were looking for another job, but it would be very hard to show that, you didn't look for another job hard enough. The courts are always going to be in favor of the employee. Now, with respect to reasonable notice under the common law, instead of getting the 1 week a year, the courts have been awarding about 1 month a year. But recently, there's been a trend that even if you're a short-term employee, they want to make up for that, let's say, firing, and not just give you 1 month for 1 year, but there are cases now where someone can work for 1 year and get 3 months. I have, had cases where someone works for 6 months and we get them 3 months. Someone works for 3 years and we get them 6 months. All because that short-term employees have to be treated fairly, of course, and that it's hard for them to, find another job right away. So you cannot just say that there's just a rule of thumb that's capped at 1 month for each year of service, which is, of course, a lot more than the 1 week under the Employment Standards Act. The other thing that's calculated under reasonable notice is whether or not someone was induced to leave secure employment. So when I first moved to Toronto, one of the first cases I had where someone had worked at IBM for 18 years and wanted to be a bigger guy in a smaller company, didn't get legal advice, resigned from IBM, started a new job with a small company, and after 6 months they said, Jim, I'm sorry, you're a great guy, but it's not working out, we don't have enough business. And they gave him a week because he had signed the contract that said you're entitled to only the minimum under the Employment Standards Act. So instead of getting money from IBM, if they had fired him, he resigned and got nothing, and he just got a week. He learned an expensive lesson, and that lesson is for everyone to know that the time to get legal advice for employment law is not just at the time of fire, but at the time of hire. So I try and tell all my people, and some of them who I, acted for now always come back to make sure that their hire letter is in order, because of the fact that there could be a lot of money at stake. And whether I'm acting for a restaurant worker at 20,000 or an executive earning 500,000 plus, the idea is the same. We want to try and get them the most possible amount of money in return for a release. And that I even tell clients that if someone has a contract and they're, let's say, there for 3 years, and that by the contract, even the new contract, if they've amended it and they want to give them 3 weeks, I say no. You don't have to sign a release if you're only giving them the minimum under the Employment Standards Act. So I always tell clients it's better to give them a little more, so that extra consideration in return for release bars them from them coming back for more, or going to human rights, or complaining about, disability and other factors. So it's always better, if you're going to settle a case, to give them a little more and get a release that basically protects the employer. Now, the recent cases on just cause with this willful misconduct is very, very important, because when someone is fired for no cause, just because of the fact that they say the economy is bad, or because of COVID, we're letting you go, and they say there's no cause, we're letting you go, but the contract that they signed had a clause for just cause saying we let you go without any money if there's just cause. The Court of Appeal said even though they weren't let go for just cause, because they were let go without cause, but the just cause paragraph violated the Employment Standards Act, the whole termination provisions are invalid. And instead of limiting that person to the 1 week a year, they'll now get common law. So that's how far the courts have gone to protect the employee. And even if there's a confidentiality and conflict of interest clause in the hire agreement, but it says if you violate our confidentiality or you violate our conflict of interest, we could let you go without anything for cause. Again, because it doesn't have the word willful, the court recently said that termination clause is invalid, because we don't know whether or not the violation was trivial or whether it was willful. So without that willful misconduct, whoops, oh yeah, there's my timer. Okay. So without that, what that means is that they're going to get their common law notice. So I think I had the timer on to basically keep the lecture just within the bounds. So I think that will be my summary. And then, of course, I'm looking forward to any questions that we could answer at the end. Bianca?
Great, that was great. Thank you so much. It's definitely very interesting to hear about some of the advancements that are being made in the field right now. So we're going to switch over to our next speaker, which is Mr. Christopher Sparling, and you can take it away.
I'm on, am I?
Yes, you are.
I'm wearing my lawyer's gown tonight, just for you. So we have a gown. It's all black. I'm sure you can't see, but there's a gown. There's a vest, what we call tabs. And then we have what is called a wing collar. As Tony will agree, I think that wing collar, it's over, whatever, 150 years old. That's what they always wore, was wing collars. So there you are. This is a lawyer who practices in Toronto. And this is what we do when we go to court. I started practicing law in 1975, which is probably long before you were even thought of. But I started as a general practitioner, so I did everything. I did real estate deals, I did wills, I did whatever else there was. But in the end, I focused on commercial business litigation, as well as a little bit of estate litigation. But that was a process. And when I was a teenager, like you, I was in architecture. I was going to be an architect. And I turned full face around and decided to go to law. I didn't know what I was doing. I'm going from an art-based, engineering-based area to what? What is law? Law is words, ideas, and I'm glad I chose it. So there you go. But I didn't choose it until after I'd completed law school. And this is the problem, I think, for you knowing what to do with your future. It seems to me no one can really say specifically what it is they want to do. What you need to do is to start doing it. The more you know about something, the more you like it. So it's not a matter of standing back and saying, what am I going to do? But it's a matter of taking a broad brush, jumping in and doing it. And this is what Tony and Laurel and we've all done. We've been in the, and Joanne will be speaking next, but we've been in the business, and what happens is there's a momentum develops, and you love what you're doing, as long as, I'm preaching, aren't I? As long as you focus and you try to do the best that you can. Okay. Tony talks about criminal law. That's one aspect of law, one that I don't share. It's totally different. Tony might as well be a dentist for all I know what he's doing. It's a different area of the law. So if you want to be a lawyer, it's not a matter of picking a lawyer. It's a matter of picking what kind of lawyer. Criminal lawyers are there to make sure that our police are dotting all their I's and crossing all their T's, that they don't bother innocent people. And some guilty people may get away, but the whole point is Tony is there to make sure that the police act in an appropriate manner. That's criminal law. It's totally different from what I do. Now, as far as employment law, that's another area of law, and you've heard a great discussion about that. And you've heard technically how it works. You've heard tonight an analysis by a lawyer about how the law works, you see? That's another aspect of the law, which is totally delightful. It's made up of government rules and judge rules. And so working it all out is a challenge for all of us. That is probably the best part of law for me. I've been doing it for so many years, and I'm still learning how the concepts work. So if you have an intellect, you want to do something more than, I don't know anything about business, so I shouldn't, but if you have an intellect and you're curious about words and rules and concepts and philosophy, if you like, because philosophy is buried in there, and logic, although I think Tony will agree we don't always see it. But that's the whole part of law which is so intriguing. But if you're going to be a lawyer, you have to work hard. Whether you're a sole practitioner like me, I told you at the beginning, I started in 75, and since 75, I've been totally solo, with the exception of about 6 years where I was with a very good group of people. But the point is that if you want to be a lawyer, you have to work hard. If you're going to work in a big firm, if you're going to become a lawyer and work in a big firm, they are sweatshots. You will work hard. And if you go on your own, as I have done, you will work hard too. You have to find out what the law is. And there's nobody there to tell you. And you have a lot of work to do. So if you want to become a lawyer, you have to be prepared to work. And then I think my final point is that, which is the same or similar to this second point, is detail. Lawyers are detailed. Whether you're a litigation lawyer like me and my colleagues here, you have to get all of the facts. Don't take the spin. You have to listen to the client. You have to question the client to determine what exactly happened. They'll tell you what they think you should know. But our duty, any professional lawyer has to cross-examine his own client. Forget about the glory of court and cross-examining the other side. You have to cross-examine your own client. And my point is detail. You need to go for the detail. So that's my little blurb on law. And I welcome anyone to join it. I'm leaving it soon enough. I've been at it since 75, but I really do welcome anyone to come into the law. It's a glorious profession, and don't ever let anybody say that lawyers are cheats. A professional lawyer, a good professional lawyer, is going to put the facts forward to the court. I'm talking litigation court. You put the facts before the court. You don't cheat. You don't assist your client to deceive the court. We don't do that. We don't tell our clients how to lie. It's an honorable profession. So that's what I have to say.
Awesome. Thank you so much. It was really informative to kind of hear about the comparison of some of the different fields of law there. Thank you. Okay, so we're going to go on to our next speaker then, Miss Joy Ann Cohen, whenever you're ready.
Hi, I practice employment, immigration, and human rights law. Before I went to law school, I was a journalist, and I wanted to have a direct impact on society. I didn't want to be in a situation where I was always objective and unable to take one side or another. I wanted to improve society in the ways that the people I met and the people I chose to represent thought it could be better. As well, I wanted an opportunity to communicate, to be persuasive, to be eloquent, both writing and orally. And I found that profession. I think law gives you those opportunities, and it gives you a wonderful opportunity to interact with people and to help them. What I didn't realize at that time was how analytical the law is. I came from a background in English literature, and then I was a writer. And when I went to law school, the degree of analysis was not a way of thinking that I understood initially. As I went through my first degree in law, I got an LLB, which is the only degree you need to be a lawyer. I learned how to be more analytical. And then I worked for 17 years as a lawyer and went back and got a master's degree in labor and employment law. And by that time, I really had a strong understanding of how the law works and analysis. So I graduated and I focused on employment and immigration law. And then I became an adjunct law professor, and I taught at law school. I developed a program in immigration law. I've taught human rights, and it has been a really, really rewarding career that I would recommend to people who want to have a role advocating for truth and for justice. When I interact with clients, most of them are in a bad situation. They've been fired from their job, they're facing deportation, or they're in a challenging situation. They've had difficulty finding a way to immigrate, or they've been persecuted and they're refugees. They're involved in a human rights action. They're being accused of sexual harassment or having to defend a claim like that. And one of the first things clients ask me about is confidentiality. So when you're a lawyer, everything is completely confidential between you and the client. Nothing you say is revealed to anyone except when you have the client's permission, the instructions, or the legal process requires that you say those things. Some of the people have had a good employment situation, let's say, and then they're dismissed, and that dismissal could rewrite their whole history in terms of how they think about their job. So when they come to me, I want to allow them to get all the benefit of the work they have done and the success they've had in the job, and not have the conflict rewrite history or destroy everything they've achieved. So part of my work is in preserving a person's reputation. And that's especially so when I'm dealing with cases concerning professional regulation, where I am defending the professional who has been accused. But it's always the case when somebody is dismissed, they need a good reference letter, and they need guidance as to the route that is going to serve them best in going forward. Clients can spend thousands and thousands of dollars on legal cases, and in the end, the vast majority of people, especially in the context like employment, or in many civil litigation cases, but certainly in employment, they settle the case. So what I would like to do is to find the fastest route for them to get to the goal, to get what they need from that situation. Another thing that, another way in which I approach this is that if we're going in front of a decision maker, they can win or they can lose. But in any event, what I would like them to come away with is respect for the justice system, so that they feel that not only have they had their day in court, but they also understand why a decision maker came to a particular conclusion, and they can leave feeling respect for those around us, and for other people, and for how the law works. My work environment is now as a sole practitioner working in association or working on the same floor as 35 other lawyers. As I mentioned, I practice employment, immigration, and human rights. I'm also a workplace investigator appointed by the federal government. So I basically in doing that, I investigate allegations of harassment and human rights abuses, and I provide recommendations to employers so that they improve the situation. So in practicing immigration law, I might need help from a tax lawyer or a family law lawyer, a real estate lawyer, and I call upon these other people who are sharing this space, sharing the reception area, the boardrooms, and so on for that particular assistance on behalf of my clients. I also give them ideas about how certain matters interact. For example, many people face immigration consequences after being convicted of criminal offenses, or they are deported, and potentially that means they will forever be separated from their children and a spouse who have the right to live in Canada. So I consult with lawyers who are outside my law firm. I don't have a law firm, excuse me, outside my space. I myself am a sole practitioner, so there aren't other lawyers in the firm. I work alone and I share this space. But I consult with lawyers who are both in the space and outside about the criminal consequences, the consequences of for immigration, of pleading a certain way in a criminal action. And so we have this discussion that that happens in order to get the client the best route possible, because it may be, for example, by taking a certain stance in a criminal case, the immigration consequences are less serious. I articled in a firm that worked for the Globe and Mail and for maritime law and aviation. And maritime law and aviation are in the federal sphere, and a lot of my work is in the federal sphere. Immigration is in federal jurisdiction. After I articled, I joined a small personal injury, a couple of small personal injury firms. And then I went into a space where there were a lot of criminal lawyers. I practiced civil litigation and I practiced immigration law. And in those days, it was much easier to get good immigration consequences for people who had criminal convictions. It's become much, much more difficult since then to get good immigration consequences. But because it was possible back in the late 1980s, I had a lot of work coming from that, and I learned a lot about criminal law and about immigration law, and I did the civil litigation that might be associated with these criminal cases. However, I wanted to be in a space where there were other people during the day, because criminal lawyers usually leave and go to court during the day, or else they work from their home, and the space is empty. So I would be there alone most of the day, and they would be in court. So I moved into a place, a small house on Hayden Street, which is very close to the core of downtown Toronto, with a group of other lawyers who were in a variety of areas. And that was such a wonderful, wonderful time in my practice. We exchanged many ideas. We had all sorts of referrals going back and forth. And I was extremely busy. But the way I was able to finance that is that I became a per diem Crown attorney, because I knew quite a bit about criminal law already from the work I had done before. And I worked as a per diem Crown, and I continued in civil litigation. Since that time, I'd had a few other jobs. I was senior legal counsel for the Department of Justice in Indian residential schools. And I have also worked for the Department of Justice, providing them with information about children in immigration, which is an area that I've really focused on for many years. And I've written consulting papers for them. I've also, as I mentioned, worked for the Office of the Crown Attorney on a per diem basis. But for the majority of my career, the vast majority of my career, I've been a sole practitioner working in a space sharing arrangement, and sometimes sharing secretarial help and knowledge. That's the most important part of it, sharing knowledge and excitement and research with other lawyers who are near me. So in a typical day, I would people call me. I identify the issues in their case. I provide them with guidance as to what I think is the best route for them, and I tell them why. Sometimes I negotiate resolutions for them, and I draft appeals and judicial reviews, or I go to federal court. And if I'm working in my role as an investigator, I interview the people with the complaint and the people against whom the complaint's made, their witnesses. I gather information from the employers, and I write reports. The way I stay on top of developments is by, well, initially it was by joining the Canadian Bar Association Immigration Section. Because when I started in immigration law in the 1980s, I was among, there were a group of immigration lawyers working for 5 to 10 years before that in the specialty of immigration law. But it was a new specialty. It was something that arose right right around then as a specialty. And as well, the Ontario Human Rights Code was introduced right around then. And I was the advisor to the city of Toronto on the Human Rights Code. So I joined the Canadian Bar Association, and I think it is a great way to learn about new areas of law. And you can, as a new lawyer, even when you're beginning, make a really significant impact and understand the law and achieve good results in the area of immigration law, which is a great area because, you know, people speak about diversity for individuals from different races and for all the protected grounds, gender, race, religion, but in a practical sense, by working as an immigration lawyer, you can achieve a result that addresses all those injustices, all those inequities, and tries to make the lives of people better. So that families I represented in the 1980s have grown exponentially. The individuals who I've seen now have children and brothers and sisters and their mother and father, and they have grandchildren, and they have businesses, and they have taken up the cause of equity and diversity for themselves and really promoted it, and they've taken a really beneficent view. Some of them have taken a beneficent view towards others because of their positive experience in coming to Canada. So I think in a summary, the things that I have done have really allowed me to meet a lot of people who are courageous. And that's a wonderful thing to experience in life. I think one of the real challenges of what I've done is that I have worked for nearly 40 years in an adversarial system. And what I've tried to do in a way is be a buffer for the clients. People say when they speak to me, even when they're in the highest conflict situation, that I'm very calming. They feel much calmer. So the lawyers on the other side might be sending me letters in which they're quite threatening or negative. My obligation is to show the clients settlement offers, discuss the settlement offers, give them guidance, appear for them in court. It's not my role to involve them in all the confrontation. In fact, what I try to do is to remove them from the really confrontational aspects. And in my area, some of the people are very wealthy. Some of them are extremely poor. Some of the refugees arrive at the airport with just a few dollars in their pocket. And so I think that the opportunity to represent people in the context of employment law and provide people with great incomes with advice on their employment contracts and all the benefits and the bonuses and the commissions and their pensions and things like that is really challenging. I love the commercial side of that. But for people who are oppressed, for people whose earnings are low, and people who are suffering from poverty, I'd like them to have legal representation as well. So that's my presentation. Bianca?
Yes, thank you so much. Your field definitely sounds very intriguing. Okay, so last but certainly not least, we're going to be moving. Oh, sorry, do we have a question? Oh, sorry, you're still muted, Mr. Bryant.
Just before we get into the next speaker, Janet, I did want to point out one of the facets of her presentation is the intersection of our different practices and how they come into contact with one another. Immigration and criminal defense come into play a lot. Employees who are charged with criminal offenses need to have guidance from lawyers who have the skill set of Laurel and Chris. There is much in what she says where we call upon one another to get that better expertise in order to better represent our individual clients.
Yes, thank you. That was definitely a very good point, how there's definitely some overlap and cooperation that way. Okay, so last but certainly not least, we're going to move on to our last speaker, Ms. Janet Bobcheko, whenever you are ready.
Right. Welcome and thank you all for attending today. I'm actually really excited to speak to you as prospective lawyers. And I hope, as the comments have been, I really do hope that you think about a career in law. It is certainly a demanding career, but I think that we're all here, I've been practicing for 30 years, so maybe the junior among all of you, but it's something that I enjoy and continue to enjoy on a daily basis, despite some of the long hours and things that go with it. So a little bit about me. My undergrad was at York University in political science and economics. But I did take electives in science, and that becomes important later on to what I do now as an environmental lawyer. I also, throughout my undergrad, got involved in politics, and I had always wanted to be a lawyer as long as I could remember. So it was something sort of in high school, I talked about it, and then through undergrad, I actually knocked on a bunch of doors and connections with other family members and ended up working, one day a week for this lawyer who I still keep in touch with as an early mentor 30 years on. And he gave me a chance to work for him, one day a week to show me what the ropes were. So I actually had a little bit better of an understanding about what a lawyer did. And then I worked for him for the summers between second and third year, and then third year and fourth year. And it was a really eye-opening experience working with a small shop. Going to law school, my career path is a little bit different. I did a joint degree at the University of Windsor and the University of Detroit. So I have both a Canadian law degree and an American law degree. And I also studied international law in London, England as part of that. Environmental law courses did not exist as a university course when I went through. So as Joyanne had said, being nascent in her area of law, environmental law was something that was talked about. There was some case law, but there was certainly not a career as an environmental lawyer when I first started. So, I'm a certified specialist in environmental law, so it means that our regulator, the Law Society of Ontario, has set up certain qualifications. So a minimum year, 10 years of practice, and certain hours and different types of opinions that you've given in relation to my subject matter, which is environmental law. And it's very important to me because as we've been talking with our various, other colleagues on the phone, they each have subject matter expertise in a specific area of, oops, and my lights just went out in my office. And I have to admit, I don't know how to turn them back on because I'm a new, we're just recently in our office and I changed. I don't know where my code is. So I'm going to look like a freaky Halloween image. So I do apologize for that. Maybe someone else who is still in the office can turn them on for me. We pivot, right? We get to have a little bit of humor in our life. But, you know, we learn our area of law and dedicate it, but we also work jointly with each other. And I work within our employment lawyers. I work with my criminal law colleagues. I work with my litigators on different things. So it's really important, you know, that for me, I don't practice real estate law because I promised my real estate partners a long time ago that I wouldn't practice real estate if they didn't practice environmental law. So I stick to my area of knowledge and I work with my colleagues who are experts in their area. And I think that's really important. Like as an environmental lawyer, I deal with probably 40 to 45, maybe 50 pieces of legislation at all levels of government, dealing with the federal government, from the Fisheries Act, transportation of dangerous goods, to environmental assessment. I deal with the province and our Ministry of Environment, Conservation and Parks. The name is always changing. And Technical Standards and Safety Authority for gas stations, for discharges to water, for development issue. I deal with, you know, what comes out of a stack for a company, what goes into the water, what kind of waste they create, how they handle and manage that waste, and deal with all sorts of, you know, very technical issues. But I'm not a technical person. As I said, my background is in political science and economics, not science. But I've had the fortune of working with my clients and engineers and toxicologists and chemists and fisheries biologists and all sorts of hydrogeologists, all the technical expertise that as you go through school, you accumulate friends in those areas who can also help educate you, but also with your clients ultimately. I've been very fortunate that they have helped educate me over my career to areas that are of concern with them. So I consider myself a corporate environmental lawyer. So I try to stay out of court. I work with my litigators. If there's a case, so a lot of times I act for big corporations and global corporations, and they have had historic practices that have caused the property to be contaminated, and that contamination has moved from their property onto a neighboring property. And as a result, there is litigation to try to resolve how that contamination is to be dealt with. Sometimes it involves a regulator issuing different types of orders, which are outside from a regulatory perspective. And what happens is that it gets, you know, very complicated, and that's why we need experts. So, but I don't do the litigation. I work with my litigators on it because frankly, I really don't enjoy the process of litigation, and that's okay because I do have partners, and part of it is, you know, what are you good at and what do you like and enjoy it. So I don't go to court or as infrequently as possible, but I help work with lawyers who go to court. I help when my clients are being charged by a regulator with violating some regulation, and I help defend them. So if they're charged, prior to being charged, I try to negotiate so they're not charged, or we charge different people, the corporation and not individuals. And sometimes I will work, if they have been charged, work with the Crown to find a resolution. And a lot of environmental cases we can manage with withdrawal of charges and guilty pleas and different creative sentences. So funding for universities, rebuilding of wetlands, and you just get to be creative. I'm also very curious, which means that I enjoy seeing what my clients manufacture. I've worked with clients that, you know, from food production, cheese making, canned fruits and vegetables, beverages, making cans, making bottles, making auto parts, making aerospace parts, in the mining industry, going down in mines and seeing, what mining is all about, understanding, what happens during the mining process. So environmental law for me is really an aspect to satisfy the curiosity of how things are made. And part of that is also how can we make things better so we produce less waste and emit fewer things into the atmosphere. So as environmental law and our concern about the environment has continued to grow, my practice has continued to involve things around greenhouse gas emissions, sustainability, climate change, and working with my clients again when they buy and sell companies, when they operate their companies. So I would get a really good perspective on what concerns are for my clients in the communities that they work, or if they're looking for a mine to go into a community, what they need to do to understand the impacts that their operations may have on the community that they're now going to put a big mine in. And that's dealt with sometimes through regulation, sometimes through voluntary communications. I work with Indigenous communities. So that means I've worked for Indigenous communities and helping them negotiate impact benefit agreements with mining companies. And I've also acted for mining companies, acting for them, with them to negotiate with the communities. So I've been fortunate to be on both sides of those negotiations. So it has given me a very unique perspective on helping my corporate clients understand concerns, community concerns, and being able to having had my Indigenous clients invest in me the knowledge of concerns in their community. And it is a very humbling experience working as a privileged person with Indigenous communities. And I recognize that, and I'm ever so grateful for the education that they've allowed me by participating in their communities. I've also acted for a lot of clients in the small, medium enterprise, so 50 to 100 employees, including the companies that are just starting out, technology companies. So environmental law is one of those areas that it incorporates so many different aspects of what is considered environment. And over the 30 years of my practice, that has grown. So as I've worked within the pulp and paper industry, technology has increased. So we put fewer things, we use less water, we put fewer chemicals back into the water, we kill less things. So I've always cared very deeply about the environment. And for me, my friends who were very much environmentalists, thought initially that I had sold out by working as a corporate environmental lawyer. And I said, but I get to sit at the boardroom table with these companies to help them figure out what the laws are and how they can improve their businesses. So in reality, everybody has a piece of that. So although I'm not an activist per se, I've spent my entire career working with companies to help them understand how things can be done better. And that is called due diligence when we buy and sell a corporation. So we get to investigate and look at how, if a company wants to sell its business, what aspects, what are the business terms and conditions, what are the environmental conditions, is there historic contamination that we have to deal with? And so that means, again, hiring and working with environmental consultants to investigate the land, to determine if there's anything that, at the time in the 60s and 70s when they were using these chemicals before that they knew that they were bad, that they were told to dump them onto the ground. And that was those were the instructions for a lot of companies. And now, to current days, they are being sued by current property owners for something that they did in the 70s. And so it is a lot of forensics and understanding and satisfying that curiosity. I also work with companies that are trying to expand their business by leasing different properties. And because sometimes their businesses aren't necessarily clean businesses, businesses, trying to help them negotiate terms and conditions. So if you have an inkling towards business, environmental law is again something that, you know, I work very closely with our corporate group to try to help manage those that environmental portion of the due diligence. In addition to accountants and other people who will be looking at employment issues and pension issues. Again, lawyers tend to work together. We should never work in silos because there's always an overlap with another area of practice. I also work with lenders, so with banks and financial institutions, and helping them understand whether or not they should provide financing for a company and what environmental terms and conditions there might be from an environmental perspective. So we can put a term and a condition in a financing document to lend money that says, okay, you know, we're going to give you X amount of dollars, but part of that money has to be spent on reducing your greenhouse gas emissions. It has to be on reducing the amount of water that you use and putting in new technology. So from that perspective, again, it's always innovation, and you become a trusted advisor to your clients. A lot of my clients have been with me for 20 plus years, and that relationship has developed that I've become what they call a trusted advisor. So they come to me not only for environmental advice, but for other advice to seek guidance on some of their business terms. As lawyers, we can't give business advice. We're not insured for that. But we can certainly help them talk about trends. And going forward, you know, I think it was Joyanne, you talked about, you know, how do you keep on top of what's happening? Well, with legislation at the federal, provincial, and municipal level, there's always change. And for me, the biggest change recently has been the movement and the push towards better understanding of greenhouse gas emissions and climate and environmental, social governance and sustainability. Those are things that, again, we started practicing, but there really was no practice. Nobody would pay me to give them that advice because it was forward thinking advice. It wasn't something, there wasn't a legal requirement to do something. So it's again helping them understand what might be coming in the future to help them prepare for it. Lately, there's been a lot of things dealing with greenwashing. So working with a company that produces it, we generically call it a widget. They produce some part or some product that goes into somebody else's business. And that widget, if they are selling it and making sure that they are selling it with accurate information as to what that widget can do, and that if it says it's environmentally friendly or it's not produced with chemicals, that it really isn't. So I work with our branding people and our marketing people and our labeling people and expertise. So it's a very different practice because it involves, you know, again, being able to think strategically about what issues might happen with a client. The other part of the practice that I really enjoy for me, and it's sort of like the hot calls. I can't remember which of you said that, you know, it's not a 9 to law is not a 9 to 5 job. I'm still sitting in my office. If it wasn't for you, I'd probably still be sitting in my office. And it's just because it happens to be a busy time of year. But for environmental lawyers, we also handle hot calls, and that means responding to spills and emergencies. And a lot of times those things happen at shift change. They happen on overnight shifts. So it's not uncommon for my phone to ring at 2 o'clock in the morning because something has happened at a facility and they need advice. I've sometimes turned on the radio first thing in the morning and seen that there's a fire at one of my clients' facilities. Some of my clients, we've had to shut down, you know, the runways at Pearson Airport or the 407 highway because smoke from the fire at their facility has caused visibility issues. So those are the kinds of things that sort of are very exciting part of the practice, but they're a very stressful part for our clients. And our job is there, I think it was Joyanne that you had said that, you know, they feel better after speaking to you. That's our job. We are the calm people in the room. We are the ones that, you know, help them figure out a solution. And it's never our job to make a decision for a client, but it is to help them figure out the path, to give them the best information so they can make an informed business decision about the risks and liabilities that they may face. One of the other things that I also do a lot of work, because environmental law, as I said, carries a lot of regulatory challenges, is that I do a lot of law reform work. And I too have been a member of I currently am a member of the Canadian Bar Association, where I'm on our national environmental and natural resources law section. I'm the former chair for Ontario Bar Association for the environmental law section. And these organizations really help when legislation is out there for comment. We provide comment to the regulators, to the government, to make better laws, because sometimes they don't understand potential implications of what that is. So law reform work is really important. I've enjoyed doing it. I've done it consistently. I do a lot of work with an industry organization. So it allows you, again, if you're an advocate, if you're passionate about something, to help change and to make better laws. I think one of the things that I'd like to answer for people about environmental law is whether or not you need a technical background. And I think that the answer is no. You have to have a curiosity and you have to be willing to learn. I think that's true for any litigator as well, is that you have to learn all of the technical aspects of it. So you might, deal with it, with anything that walks in the door from different ways. But having some science background or some biology, understanding construction. I deal a lot with construction companies. I deal a lot with developers, and understanding that, but having a curiosity and be willing to answer those questions, and hopefully having clients that will help educate you about that. As one of the things I've done is with the University of Guelph, actually, is with one of my clients who we needed to find out whether a chemical was toxic potentially or not, that had been in the environment for a long time. And so we started a research study, hiring the University of Guelph, working with them to determine the toxicity of certain chemical substance. So it's, again, that curiosity has led me to environmental law, because I get to explore that with my clients. I've also had a little bit of a different experience in relation to the types of firms that I have worked with. So I started out practicing with at that point was a national firm, but a smaller national firm that grew to over 300 lawyers while I was part of it, and I ran the National Environmental Practice Group across Canada. I've also been at a global firm partner with 3,500 lawyers around the world, and understanding and working on global transactions. And that's very fast paced, and it's fantastic. And my jam is, doing corporate transactional work. So, if you're up all night, you're up all night. If you're dealing with somebody in Australia or in the UK, so be it. They're fun transactions, and hopefully you enjoy the work you do with. And I will say the environmental lawyers around the globe, there aren't that many of us globally or even across Canada. There's probably fewer than 100 across Canada. We all get to know each other, and we see each other on various transactions. So it is a very collegial bar, because we will see each other on opposite sides of it. And now I'm at a regional shop, which is about 120 lawyers in 3 floors in a tower in downtown Toronto, with all the disciplines that I need from no immigration though, but with our employment lawyers, our litigators, our corporate guys, real estate, the regulatory practice, tax, all of those different things, securities. So I get to interact with them and help their clients. But it is lovely to walk around the floor, and now that we're all back in the office, and to see and have the support to be able to bounce things off of. So it's a very different practice from my colleagues, but it's a good opportunity to hear and talk about the different things. I think the one common element that we've all shared is that you have to love it, and you're going to work hard. But hopefully you will continue to enjoy it after so many years of practicing. That's it for me.
Awesome, thank you so much. I know environmental law is something that I personally find very interesting, as well as it was great to kind of get a perspective of a lawyer who's not necessarily in court all the time. So it was great, thank you. Just before we jump into our question and answer period, we do have some advice here from one of the lawyers who couldn't join our panel tonight, but he wanted to just share a piece of advice with some pre-law students. And his advice here is just to relating to admissions. investigative course on the LSAT as the type of questions and honors come naturally, so it can help improve your score materially. So something for our pre-law students to take with them. So I will shut off the recording, and with that, we can jump into the question and answer period.